Hello everyone, this is Advocate Abhishek Charan, Legal Associate at NRI Legal Services. Today, I'm here to apprise you all with all the important things you need to keep in mind while buying and selling properties in India by NRIs. In this video, I would be covering the general laws and the tax provision pertaining to buying and selling of properties, and thereafter the repatriation of funds, income earned from the sale of such properties, and much more. So stay tuned till the end of this video so that you don't miss out anything significant. Buying a property undeniably ranks as one of the greatest Indian dreams, so it doesn't matter which part of the world you live in. A home in India is simply a must, and the Indian laws make this fairly easy. In this video, I will give you a lowdown on all that you want to know if you are NRI and want to buy a property in India, as per Foreign Exchange Management Act of 1999. To begin with, we must understand the definition of NRI as per FEMA. An NRI is a citizen of India living outside India for the purpose of business, employment, or any other vocation which indicates his intention to live outside the country for an indefinite period of time. An Indian would also be termed as an NRI if his stay in India is less than 182 days. Now, I will be discussing the mandatory regulation with regard to buying of property in India. The Reserve Bank of India generally allows the NRIs to buy residential or commercial properties in India. However, this permission does not allow the NRIs to buy agricultural land, plantation property, or a farmhouse. I would like to add here that if a person already owns a property in India and subsequently acquires the NRI status, then he or she can hold that property with his NRI status. Moving further to funding and financial transaction. When buying a property, NRIs are required to carry out all the transactions in Indian currency and through local banks. This means that NRI, those who wants to invest in property in India, are required to have an NRI account in one of the authorized Indian banks. Prior approaching the banks for funds, NRIs must get their documentation verified by a competent lawyer in order to make sure that they are in order. In addition, they must obtain a certificate from the seller stating that there is no lien attached to the property. Further, if the property is jointly held or inherited by the seller, then the NRIs must ensure that the title of the property is clear. Moving further to tax benefits, NRIs are also eligible for tax benefits which are already available to Indian resident buyers. If the property is sold within 3 years of buying, then income occurring will be taxed under short-term capital gains. If the property is sold after 3 years of buying, then they can exercise the option of cutting down the long-term capital gains by investing the same amount in another property. Moving further to repatriation of funds, the NRIs are required to follow certain guidelines as stated by FEMA for repatriating funds to foreign country. Number 1, the NRI should have bought the property as per FEMA directives that are applicable at the time of buying the property. Number 2, the funds being repatriated should not exceed the original investment if the payment was done by way of foreign exchange remittance through normal banking channels or the funds held in FCNR banking accounts. Now coming to the second part of the video, that is selling of property in India by NRIs. The recent boom in Indian real estate industry has encouraged the NRIs to sell their properties. However, NRIs must take note of the special provision in the Indian tax laws before selling their properties in order to ensure a smooth transaction and to avail maximum benefits. General provisions related to selling of properties. Number 1. An NRI can sell his residential or commercial property in India to a person who is a resident of India or an NRI. Number 2. An NRI can also transfer his residential or commercial property to an authorized dealer or housing finance institution in India through mortgage. Under special permission, an NRI can sell his agricultural land, plantation property or farmhouse in India only to an Indian citizen. Moving on to repatriation of funds to foreign country. There are certain guidelines that has to be followed by NRIs while repatriating funds to foreign country. Number 1. The property must have been purchased in accordance with FEMA directives that are applicable at the time of purchase of property. Number 2. The amount repatriated should not exceed the original amount paid for the property if the property was acquired in foreign exchange remittance through normal banking channels or out of the funds held in FCNR banking accounts. Now, I will be listing down the documents that are required to carry these transactions. The documents are passport, PAN card, tax return receipts, address proof, sale deed, documents from the society if the property is situated in a society, and lastly, a clearance certificate from the seller that the property is free from every kind of charge. As we specialize in property related matters, we get a lot of queries from NRIs living abroad, whether is there any limit to the properties that an NRI can buy in India. I would like to tell you there is no limit on the number of residential or commercial properties that an NRI can own in India. However, there is an exception, as I've already told you, that an NRI cannot buy agricultural land in India. Another question that would arise in your mind would be how to fund the purchase. The payment for the purchase of the property can be made either by way of funds remitted to India from abroad through regular banking channels or through balance in NRO, NRE or FCNR banking accounts. In case you have any query, you can write us an email on query@nrilegalservices.com. Don't forget to like, comment and share this video. If you want more informative videos, do subscribe our channel. Thank you so much.